Well, I'm delighted to be with you, and thank you so much for the opportunity to talk about the Supreme Court decision formerly known as National Federation of Independent Businesses versus Sibelius, more commonly known as the Obamacare case. This is a subject I've been studying and following for a couple of years now, and I never really get tired of talking about it because it's so interesting. This is a case and a decision that really revisits the fundamental relationships among federal government, individuals, and state governments, and reminds us, if we care to study it and if we care to think about it, why the framers of our Constitution did what they did, what they were intending would be the result of that, and then how, in modern society, we come to cope with some of the limits, perhaps, that they put on government, both federal and state. But let me give you a little bit of background before I dive into the decision. Among other roles, the Attorney General's office is the law firm for state government. It is also the law firm for the people of Indiana as a political body. Essentially, we're the lawyer for you in your capacity as the popular sovereign. And in that regard, we safeguard Indiana's prerogative to enforce its own laws without interference from the federal government. The corollary is that we not only defend state laws when they're called into question, but we're mindful of what the federal government's limits are, and we will take action if we see the federal government exceeding its limits and perhaps impinging on state court responsibilities. Now, in that regard, the Attorney General and I were given a very important assignment in early 2010 when Senator Lugar invoked a rarely used state law. It's not commonly known about. There's a law that says a member of Congress can ask the Attorney General for advice regarding a pending federal bill and what impact it might have on the state. And so Senator Lugar invoked that statute and asked us to take a look at a particular bill that was pending, and it was legislation that would mark the biggest expansion of federal government authority since the New Deal. Of course, I'm talking about what came to be known as the Patient Protection and Affordable Care Act, commonly known as Obamacare. So we undertook several weeks of research, and we delivered a 55-page analysis to Senator Lugar. Among other things, we concluded that a proposed requirement that became famous in its own right, that individuals buy health insurance by 2014 or face a penalty. This is the provision commonly known as the individual mandate, euphemistically described by the federal government as the shared responsibility payment. That would be an unprecedented expansion of government authority. We also conveyed some of the hard facts, which, for example, that the bill's proposed expansion of Medicaid would cost the state $2.4 billion over 10 years. And it would cost us that money on pain of losing our entire Medicaid grant from the federal government. These, needless to say, were alarming conclusions, and they really identified some threats not only to individual liberty, but also state sovereignty and fiscal solvency for the state. So after Congress passed that Affordable Care Act, notwithstanding our 55-page analysis, several states joined a single lawsuit, to challenge the constitutionality of the Affordable Care Act. Indiana joined a short time later, and before it was all over, the case included 26 states, the National Federation of Independent Business, 2 of its members who are small business owners, subject to many of the law's requirements, including the individual mandate. The contentions of the plaintiffs in the case were many, and there were some that fell by the wayside as the case moved on. But the 2 central components of the case was that Congress, with the individual mandate, had exceeded its constitutionally enumerated powers, and that the Medicaid expansion, tied as it was to our existing Medicaid grant and not merely a set of conditions on the new Medicaid grant, was unconstitutionally coercive in violation of state sovereignty. We started off on the right foot. The federal court in Pensacola found the Affordable Care Act unconstitutional, principally because of the individual mandate, and was unable, this judge was unable to unwind the individual mandate from all of the other provisions of the Act. So his conclusion was that the entire thing had to go, that the individual mandate was so deeply embedded in all of the provisions of the Act that none of it could survive without the mandate. The case was appealed to the 11th Circuit Court of Appeals, and they affirmed in part, they agreed with the district court that the individual mandate was unconstitutional, that it exceeded Congress's powers, but they weren't convinced that the whole act had to be thrown out. They made an attempt to try to save many of the other important provisions, including the Medicaid expansion, much to the state's dismay. Well, the case was then appealed to the Supreme Court, and I have to add, it was essentially appealed by everybody. Usually you just have one party that loses in the Court of Appeals, and they're the ones that take it to the court. Here, everybody lost something, and something big. So we were all in agreement that the U.S. Supreme Court should take the case. I don't think there was ever much doubt the court would have to do this. Ours was hardly an obscure case, and there were many others like it pending around the country, both by a few other states and many individuals and businesses. So we, I think everybody expected that this would be a case that would go to the court and command quite a lot of attention, both from the court itself and from the public at large. Now, I have to add that once the briefing was complete, and that would have been the early part of 2012, the court went to set oral argument. We didn't really have much idea how much time they would set aside for the argument. We had many issues in the case: the individual mandate, the Medicaid expansion, this issue of severability, can the rest of it survive if the individual mandate goes down, and some other ancillary issues. So we thought this is an awful lot for one typical argument session, but we didn't have any idea that they would set it for 3 days of argument. That is the longest argument for a particular case, the most time devoted to oral argument for a particular case since Miranda versus Arizona, which of course gave us the well-known Miranda test. So this was a sign that the court really knew that it was undertaking a blockbuster case, that this was going to be once in a generation kind of a decision. So on June 26th, after all that briefing and argument, the court handed down a decision that mostly upheld Obamacare. The vote was 5-4. But it did so only after some fairly significant judicial rewriting that I will outline in a moment. The end result, not exactly what the plaintiff states had hoped for, but it does in many respects ward off Congress's unprecedented power grab here. And it warns future Congresses that there are indeed significant constitutional limits on federal power, and that those limits relate not only to individuals, but also to how Congress treats state governments. So there's a lot to unpack with this decision, and I want to review both of the main components of the court's ruling. First with regard to the individual mandate, and then second on Medicaid expansion. Just to revisit briefly what the individual mandate in fact requires, it says individuals have to purchase or subscribe to health insurance through Medicaid or some other offering by 2014, or pay a penalty. $695 is the baseline penalty for individuals, and it's adjusted based on income and other factors. And that penalty has to be paid to the IRS with individual income tax returns. We argue, the states, that Congress had no power to impose such a mandate plus penalty directly on individuals. That in the name of protecting individual liberty, our founders did not bestow unlimited power on Congress. The federal government does not have what government lawyers like to call the state police power, or the general police power, which is basically the power to enact any law that benefits the health, safety, welfare, ethics, morals of the citizenry. Congress, in fact, has only limited powers, and limited powers specifically enumerated by the Constitution. Now, with Obamacare, Congress had done everybody a favor. They had specifically asserted what power they thought they were invoking. And they said, we are invoking the power under Article 1, Section 8, Clause 3 of the U.S. Constitution, commonly referred to as the Commerce Clause, which provides the authority to regulate commerce among the several states. So our position was that this was not regulating commerce. This was commanding commerce. This was taking people who didn't want to be engaged in the marketplace for health care insurance and requiring them to enter that marketplace. Our position was that if Congress could, in the name of regulating commerce, compel people to buy health insurance and impose a penalty if they did not, it could compel citizens to buy anything. Broccoli, I think we've all heard that one. GM cars, who knows, maybe even Solyndra solar panels. Congress, in essence, was regulating inactivity. That was the line that we were drawing, activity versus inactivity. Something he had never done before. And that power is the equivalent, we said, of the general police power. In the lead opinion, Chief Justice Roberts first concluded that, indeed, the individual mandate, as written, exceeded Congress's powers under the Commerce Clause. Congress, he said, cannot command that individuals engage in commerce in the name of regulating that commerce. Nonetheless, as we all know, the Chief Justice upheld the individual mandate by declaring it to be within Congress's taxing power. This was possible, as the Chief himself basically acknowledged, by opting for something other than what we might call a natural reading of the Act. The statute, he said, and I'm quoting here, reads more naturally as a command to buy insurance than as a tax. And I would uphold it as a command if the Constitution allowed it. Okay, one would hope so, but there he is. He says, if it's the Constitution allowed it, I would say it's a command. But it is only because the Commerce Clause does not authorize such a command that it is necessary to reach the taxing power question. And it is only because we have a duty to construe a statute to save it, if fairly possible, that the individual mandate can be interpreted as a tax. So in Roberts' view, as he put it, this is quoting again, the question is not whether that is the most natural interpretation of the mandate, but only whether it is a fairly possible one. So, the net result, the Chief Justice said, this, what we've talked about as an individual mandate, is a command to buy insurance on pain of penalty. It's not really a mandate at all. We're all just dreaming about that. It is a choice instead. It is a choice provided by Congress. You can buy insurance, or you can pay the tax. Either one. Buy the insurance, pay the tax. How very friendly of Congress to have given us that choice. So without getting too far into the weeds, I did want to provide a bit of a critique of this logic. First, as the joint dissent, that was what we might think of as the typical conservative wing of the court, Justices Scalia and Thomas and Alito and Kennedy, they went through the Chief's opinion and pointed out some very astute observations. And what they explained was that while the courts should indeed defer to legislative bodies and avoid constitutional questions when reasonable to do so, they should not rewrite statutes in order to save them. The joint dissent had this to say, and I think this is one of the best lines of the whole opinion. They said, to say that the individual mandate merely imposes a tax is not to interpret the statute, but to rewrite it. Judicial tax writing is particularly troubling. Taxes, they said, have never been popular. CEG, Stamp Act of 1765. The taxation theory also has constitutional roadblocks of its own. And the Chief Justice's opinion really did not satisfactorily address these roadblocks, in my view. Even setting aside the very important debate about whether the mandate plus penalty can fairly be described as a tax under any definition, if you conclude that it can be described as a tax, that doesn't end the constitutional discussion. Congress cannot simply enact whatever taxes it wants. There are limits on its taxing power. Recall that it took a constitutional amendment just for us to have an income tax. Well, the reason for that is that Article 1, Section 9, Clause 4 of the Constitution says that, quote, no capitation or other direct tax shall be laid unless in proportion to the census or enumeration. Well, no one was arguing that this tax had somehow been laid in proportion to population by state, so there was no doubt that if this was to be deemed a direct tax or a capitation, that it would be unconstitutional. So the Chief Justice had to address whether this was a direct tax. He said that, well, we don't know, we have never seen anything like this. We have cases, the Chief said, showing what is a direct tax. We know an income tax is a direct tax, allowed only by constitutional amendment. Property taxes are direct taxes. What we might think of as a tax on the person, the word for this is capitation, they use in the Constitution. That's a direct tax. What else could be a direct tax? What about a shared responsibility payment or an individual mandate? No precedent for that. So the court said that this was not a direct tax in part because the obligation to pay depended on whether the person had bought insurance, so there's that initial choice, and the precise amount would depend on various circumstances, including the level of income. But mostly the court concluded that this was not a direct tax because it had never before declared such a tax to be a direct tax. So I want you to note the two ways that the unprecedented nature of this law was used by the majority to reach different outcomes. So the Chief Justice had earlier in the opinion, when discussing the Commerce Clause, said that because the court had never approved a congressional command to buy a product, its command to do so here was likely unconstitutional. But now he was saying that because the court had never invalidated a tax like this, that it must be okay. And that brings me to what I think is the most perplexing point of this opinion from the Chief Justice. And he said, there may be a more fundamental objection to a tax on those who lack health insurance, which I think is a fair description of what we have here. Even if only a tax, it remains a burden that the federal government imposes for an omission, not an act. Starts to sound a lot like inactivity that was relevant under the Commerce Clause. And he acknowledges that. He says, if it is troubling to interpret the Commerce Clause as authorizing Congress to regulate those who abstain from commerce, perhaps it should be similarly troubling to permit Congress to impose a tax for not doing something. But not to fear, he says. Quote, it is abundantly clear that the Constitution does not guarantee that individuals may avoid taxation through activity. A capitation, after all, is a tax that everyone must pay simply for existing, and capitations are expressly contemplated by the Constitution. Yes, true enough, when they are apportioned, which is the remaining logical step that the Chief Justice ultimately does not grapple with. It is certainly the case that a direct tax is a tax for doing nothing, but it has to be apportioned by population, and this was not. Okay, so now we'll move to the Medicaid expansion. So the Affordable Care Act would have covered many uninsured people by expanding Medicaid and requiring states to afford Medicaid to effectively up to 138% of the poverty level of the population. So to achieve that, to encourage states to make that expansion, the Act said that states that did not expand their Medicaid programs by 2014 would be threatened with the loss of all of their Medicaid funding. It wasn't just a question of, here's some new funding to expand your program. It was, we're going to put all of Medicaid on the block, and you will get none of it under threat unless you expand your program. Well, the state's theory was that this was unconstitutionally coercive and that it impinged on states' priorities, their ability to set their priorities as a sovereign. In prior cases, the Supreme Court had said that such conditions on federal spending are usually within Congress's authority, but it had warned that if Congress went too far, its conditions on grants to states might well be invalidated as coercive. Well, here Congress went too far. The court said that, quote, instead of simply refusing to grant the new funds to states that will not accept the new conditions, Congress has also threatened to withhold those states' existing Medicaid funds. The states claim that this threat serves no purpose other than to force unwilling states to sign up for the dramatic expansion in health care coverage affected by the Act. We must agree, the court said, when conditions take the form of threats to terminate other significant independent grants, the conditions are properly viewed as a means of pressuring the states to accept policy changes, and that that's not allowed. The result is that it is now optional for states to decide whether to expand their Medicaid programs, which releases the states from a huge financial threat. How Indiana will respond to that and how Indiana will proceed with regard to Medicaid is going to be up to the next gubernatorial administration, the next General Assembly. Regardless of what the decision by those political bodies is, I think it's significant and encouraging that the Supreme Court has ruled that the federal government could not threaten to cut off states' current Medicaid funding as a punitive measure. The court, in effect, reaffirmed that states are sovereigns and not mere subdivisions of the federal government. But I think we have to observe that actually is a very profound statement, and it has implications for states and not simply the federal government. Sovereign status carries important responsibilities. One of the most important passages of the Chief Justice's decision is when he described the precedents relating to federal spending conditions. And he said that in the typical case, we look to states to defend their prerogatives by adopting the simple expedient of not yielding to federal blandishments when they do not want to embrace federal policies as their own. The states are separate and independent sovereigns, he said. Sometimes they have to act like it. Court's reminder of state responsibility, I think, provides an important opportunity to revisit our basic premises for accepting federal grant money on many fronts. The federal government, we always have to remember, spends money to get its way, not merely out of the goodness of its heart. With every grant offered, it is important to ask, are the federal government's priorities our priorities? Well, in conclusion, as the Attorney General has said frequently, now that we have the Supreme Court's ruling, whether we agree with it, we have to respect it, and we have to act accordingly. Now that the limits of the federal government's authority are more clearly defined, the issue of health insurance coverage for uninsured people becomes a question for legislators and policymakers once again.